Hello guys, once again welcome back to our YouTube channel. So today we're going to be talking about the issues of buying or receiving stolen items. The question really is, will I be guilty for buying a stolen item if I didn't know the item was stolen, right? Now, because if you look around, to be sincere with you, most people drive stolen cars. They use stolen iPhones. They wear stolen shoes. And sometimes people literally go for these stolen items because they're cheaper. So what are the liabilities ascribed to this? Because we all buy things every day and we sell things every day. Sometimes you may know that the items are stolen, and that's bad and in bad faith. Sometimes you don't know that the items are stolen. Now, under common law, quickly look at it from the civil perspective first before we go to the criminal angle. Under common law, there's a principle called nemo dat quod non habet, and that's called the nemo dat rule. So what the rule means is that you cannot give what you don't have. So basically, um, where someone steals an item, ordinarily it is not his own. So when he gives it to you, it basically means that um, he does not have the title to that property or to that item to pass across to you. There are, however, various exceptions to the nemo dat rule. All right, these exceptions generally seek to protect a bona fide purchaser of goods for value without notice to someone who does not know or is not aware that those items were stolen. Now let's look at the criminal aspect of it. There is the criminal code in Nigeria, which governs offenses in the southern part of Nigeria. Then there is the penal code, which governs offenses in the northern part of Nigeria. Now, the criminal code under section 427, which is applicable to southern states in Nigeria, provides that any person who receives anything which has been obtained by means of any act constituting a felony or misdemeanor, or by means of any act done at a place not in Nigeria, which if it had been done in Nigeria would have constituted a felony or misdemeanor, and which is an offense under the laws in force in the place where it is done, knowing the same to have been obtained, is guilty of felony. What that part is saying is that if you steal an item, all right, and you sell to someone else, you that stole the item, you're guilty of stealing, and the person who bought the item, knowing that the item was a stolen item, is also guilty of obtaining or receiving stolen item. Now let's look at what the law provides for in the northern states so that we can aggregate and put everything together. Section 316 of the Penal Code, which is applicable to northern states of Nigeria, provides that property, the possession whereof has been transferred by theft or by extortion or by robbery, and property which has been criminally misappropriated. So, for example, properties obtained through official corruption or in respect of which criminal breach of trust has been committed, is stolen property, whether the transfer has been made or misappropriated or breach of trust has been committed within the northern region or elsewhere. But if such property subsequently comes into possession of a person legally entitled to the possession thereof, it then ceases to be stolen property. So, from the above, there are four elements of the offense of receiving stolen property. One, the property must be received. All right, the property must have been received. Two, the property must have been previously stolen. All right, that's what the law says. So these are the conditions you have to look at before you can conclude that an offense of that nature has been concluded. One, the item must have been received. Two, the item must have been stolen. Three, the person receiving the property must know that it was stolen. Four, the receiver must intend to deprive the owner of his or her property. So it can be deduced from what I just said that where a person receives a stolen property, is not aware of the dubious nature of the possessor's title, that is, he is not aware that the item he's purchasing is a stolen property, and as long as this unawareness continues and he did not deal with the property in a manner suggesting that he wanted to deprive the real owner of his property, he is not guilty of an offense. But what must he do if he becomes aware that the item he bought is a stolen item? He has to return it to the rightful owner if he can reach the person, or report to the police and submit it to him. Now, this lecture basically is there to guide those of you who go to Computer Village to buy stolen phones. You want to buy an iPhone that goes for 500,000 naira, and somebody tells you it sells for 80,000 naira. Without doubt, you should know something is wrong somewhere. All right. So the law can infer that you knew it was a stolen item. Or you want to buy a Toyota Camry which goes for, let's say, 3 million naira, and the person tells you, oh, just bring 500,000 naira. It doesn't have papers or anything. So that tells you that something is wrong somewhere. And if you buy a stolen item knowing, or you were in a position to ordinarily know and you turn your face away from knowing, you'll be guilty of receiving stolen item. All right. So I want to believe this lecture is helpful. So going forward, you should know what to do and what not to do in situations of this nature.